I am the legal director of CASE. I run the legal services. We have 5 attorneys. One of our newest attorneys, in fact, the newest attorney, is sitting right up here, Danielle Johnson. We're very excited, as is our newest paralegal. So I forced them to come to this today as well. Just to let you all know kind of where we're coming from, and you all have heard about the great work of LAF today and the work that they've been doing for survivors of sexual and domestic violence. And I can say LAF is a great partner of ours as well. In terms of what the services that CASE provides for survivors of sexual violence, we focus really in 5 main areas. We do victims' rights representation as victims' attorneys in the criminal justice system, both at the law enforcement stage and then after indictment. We also do civil litigation and protective orders. Did Micah talk about the Gender Violence Act? Yeah. So what Micah talked about today with the CNCOs and the Gender Violence Act, we do those as well. We provide employment advocacy under the Victims Economic Safety and Security Act, under Title VII, under the Illinois Department of Human Rights, and then also education advocacy, which is what I'm talking about today. And then finally, we represent survivors of sex trafficking in helping to vacate and expunge their criminal records under the Justice for Victims of Sex Trafficking Crimes Act. So that's a very quick summary. But again, our legal services information is here. The presentation that I have for you all today is one I usually do in an hour, so that's why I'm cutting a lot of this stuff so that we can get into the meat of talking about educational advocacy, because things have changed a lot just in the last few weeks. So today we're going to talk overall about laws that address gender-based violence in schools and here in Illinois. Specifically, we'll look at the federal law of Title IX and the Clery Act, and then finally the Illinois law, the Preventing Sexual Violence in Higher Education Act. And then I'm going to talk, since I know some of you here are not lawyers, we're going to talk about how advocates and attorneys can help advocate for their clients within the educational realm. And then finally, I'm going to touch very briefly on the issue of defamation and privacy, because what we have seen is that our clients that are most at risk of being sued for defamation are our clients who are students who have reported sexual or dating violence to their schools. So I will touch on that at the end as well. Okay. A lot of you might know this already, so I'm not going to really go into it very deeply. But, you know, the statistics that are out there, they're disputed in many ways, and we try to use some of the more conservative ones. So you've heard 1 in 4 women, 1 in 5 women. We go with the 1 in 6 women and 1 in 33 men are victims of sexual assault during their time in college in university. And we also know that people who are subjected to sexual assault or rape within the school context or by a classmate are the least likely people to report, either to the officials at their school or to law enforcement. And we do know that a lot of these sexual assaults also happen off campus. So it says 1 in 3 happen off campus, which would tell you 2 out of 3 happen on campus, which make it not purely, but it does make it the responsibility of the schools to address those issues. So I know that a lot of people ask, why are schools even looking into this issue? You know, back in the 1990s, Anita Hill sat in Congress and answered questions related to sexual harassment against her by now Justice Clarence Thomas of the U.S. Supreme Court. And at that time, people were saying, why should employers have to address sexual harassment? We don't ask those questions anymore. And it's because actions that take place in an area where you control, where you as a an entity, as an organization, as a company, control are your responsibility. Much like if somebody slipped and fell while at a store because your floor was wet, it is the responsibility of your company to address that issue. And what the courts have told us is that access to education is a fundamental civil right for students. I'm going to take a deep breath because I just jumped right in now. And if there is a civil right that is protected under our law, under our Constitution, then anything that is a barrier to accessing that right has to have a remedy. And what the courts have said is that gender-based violence is an obstacle to that right to education. And now in order to really get to the schools, you have to find a place where there's a hook for the government to have control over them. And so we talk about federal funding. So if a school takes any form of federal funding, they are required under the law to address any type of sexual violence or gender-based violence, because that is discrimination under the law. And when I say if a school takes government funding, if they have one student who takes $1 of federal loan money, they are taking federal funding. So that would tell you that pretty much every single school in this country is required to address discrimination under U.S. law. Okay, so now we're going to get into Title IX. Anybody who's been paying attention to issues related to campus sexual assault, to what's happening with the current Department of Education, will have heard about Title IX. But a lot of people still are confused about what it means. Now, Title IX is not very long. It is 37 words long, in fact, and they are all here. What you will see in reading this is that there's nothing addressing gender-based violence, dating violence, stalking, sexual assault, and yet through the courts, through the government, this has been interpreted to address those issues. So Title IX, I usually ask people who played sports in high school or college, but I'm going to skip that. Title IX was originally put in place because of the disparity of funding between sports for men and sports for women in college campuses, and to address that disparity. But it has grown to address sex discrimination in all of its forms within an educational setting. And that's through court cases, through Supreme Court cases saying that sex discrimination comes in the form not only of disparity in funding, but also through gender-based violence, also through sexual harassment. And then it put on the Department of Education, or the government put on the Department of Education, the requirement to determine what responsibilities the schools will have to address that sex discrimination in its forms. So various administrations have put out there various things called substantive guidance documents. They're often called Dear Colleague letters because they start, Dear Colleague, we would like to tell you what we want to do with Title IX and what you are now required to do under the law under Title IX. And the most famous Dear Colleague letter came out in 2011 under the Obama administration, and basically instituted a number of new requirements for schools under Title IX to address specifically the issue of sexual assault. As you might be aware, about 3 weeks ago, that Dear Colleague letter, along with additional guidance that was passed issued in 2014, was rescinded by the Department of Education. And a new Dear Colleague letter was put into place that dramatically changed what we're looking at with regards to Title IX and what the landscape has looked like for the last 6 years. And we are now trying to deal with that, and I am going to try to provide as much as possible information to you all about what this will look like moving forward, at least at this point as we are aware. What I do have to say is if you are interested in reading letters, I would advise that you go and look at the 2017 Dear Colleague letter that was just recently put in place, because that will give you a little bit more guidance. It is available on the Department of Education Office for Civil Rights website. If you just put 2017 Title IX guidance in Google, it'll pop up. It did keep in place a 2001 Dear Colleague letter from the Bush administration, as well as 2006 revised guidelines on sexual harassment, which are actually really good documents and really helpful documents, and actually are a little bit against the new guidance that came out, but you know, I really am not holding to the current administration to figure out when things are, you know, not working together. So anyway, moving on. So we are going to talk about what Title IX requires, when it's triggered, but then I'm going to talk about how that applies to your clients here in Illinois. Okay, so when is Title IX triggered? Well, there has to be, as I said, a connection to the university or to the school. Title IX applies from basically pre-K until postgraduate classes, and you actually get out of school. So when I say any school that receives federal funding, I'm not just talking about universities. A lot of people think of Title IX as applying only to higher education, but it applies to any of the people you work with who are in high school, to middle school, even to a kindergartner who might be what's the word I'm looking for? Who may have experienced sexual abuse. And so this is an incredibly important law to understand when it is required or when it is triggered. So if there is connection to the school, Title IX is triggered. But in terms of how these connections are added together is what determines the responsibilities of the school. And this is a bit of a complicated thing, so if you do have questions, you're always welcome to give us a call at CASE. Micah Held, who just talked, is also has a lot of experience working in Title IX, so I'm sure she would be happy to address questions as well. Basically, if the victim is a student, employee, or someone who has to be on campus, the Title IX is triggered. This applies whether the person is male or female or non-binary. If the perpetrator is a student, employee, or again, someone who is required to be on campus. The obligations are more so when the victim is the person on campus than when the perpetrator is the person on campus if the victim is not a person on campus. So that's kind of up in the air in terms of what the schools are required to do, but there is that hook if the perpetrator is someone who is attached to the school. And then finally, if it happens on the school campus, the Title IX is triggered. If it happens off campus, the school has to determine whether it happened in the context of an educational activity, so say a field trip, or study abroad in Australia. One big one is archaeology digs. That's been happening a lot with PhD students being victims of sexual assault. Then they also have to determine whether what happened off campus actually creates a hostile environment on campus. Now, hostile environment is a very specific legal determination, but basically it means, does the environment that is being created by the violence or by the fact that the violence occurred, does that make it, is that a barrier to the victim or to other students receiving their educational access? So again, complicated issues of how to determine that. It's not necessarily your responsibility to figure that out. It is the school's responsibility to figure that out. Okay, so if Title IX is triggered, what is required? Now, there used to be a lot that Title IX required. It was vague, and it left a lot of leeway for the schools, but there was still a lot of guidelines for the schools, and now there's a lot less. But what has remained is that the school has a duty to respond where it knows or reasonably should know of an incident of sexual misconduct. And that duty to respond is to prevent its recurrence and remedy the discriminatory effects. Again, it's somewhat vague language, and how a school implements that is still very much left up to the school, but that is the fundamental duty of the school. Now, in terms of where it knows or reasonably should know, a lot of schools will say until a named victim comes forward and files an official complaint, we don't have any requirement to address this issue. But that is not what guidance says. The 2006 revised guidelines on sexual harassment says even if the student does not, the victim does not report directly, even if they don't want to be engaged in the system, the school still has a duty to investigate and still has a duty to respond to ensure that there is no hostile environment and to ensure that there's no continuing discriminatory effects. Now, I'm saying this because I currently have a case where, unfortunately, we lost with my client, who was the only victim who was able to come forward. The other 6 victims have chosen not to come forward because of the risk that they believe there is to their reputation and their standing at the school, because unfortunately the perpetrator is pretty powerful and pretty well known within their department. And but the information about those 6 women who were victimized is still known to the school. There are people who know about it, and they know that the sexual misconduct has happened. And yet the school still refuses to investigate because they said until those named victims come forward, we don't have any obligation to investigate. That is not true. That is actually a violation of the Title IX guidance and also Illinois law that is still in place. So that's something for you all to be aware of, that if your clients do not want to come forward and have themselves named necessarily, they can make anonymous reports. They can participate as little or as much as they want, but there is still a requirement for the school to respond in such a way that it does prevent a recurrence of the gender-based violence. Now, if they choose not to participate, it might be limited how much the school can do, but the school still has a duty. Yes?
So how is the school held accountable? So if they don't comply, how are they held accountable?
We'll get to, at the end, the violations. Sorry. No, it's fine. But the most basic way they're held accountable is through a complaint to the Office for Civil Rights of the Department of Education. We'll again get to how worthwhile that is at the end. There is a very small private right of action for a student to sue a school, and I'll get to that in the end. But that is, I mean, we're in a difficult position now. It used to be that if I filed a complaint with the Office for Civil Rights, I know the investigation was most likely to be opened if I could show clearly a violation of Title IX. Now I'm not sure if that will happen. And so we are in a new era, and I'm going to talk a little bit about kind of what we're hoping to see moving forward when we get to that as well. But it is a good question. Enforcement is a big question. Okay. So yes, so the school has a duty to respond. The school must determine whether a hostile environment has been created. And what previously the guidance said was one act of sexual assault was enough to create a hostile environment for the entire campus. Now we don't know if they would say that. They might say, yes, it's a hostile environment for this student, but not for everyone, and so the school doesn't really have to change anything. So we're still, we haven't had enough guidance, we haven't had enough cases to find that out. They have to designate at least one employee as a Title IX coordinator. Because they rescinded the guidance on who could be a Title IX coordinator, we're now not sure exactly who gets to be a Title IX coordinator. There used to be all sorts of requirements regarding training and bias, and a dean can't be a Title IX coordinator. The person who runs student affairs can't be a Title IX coordinator. Now it's just one employee. That's really the only guidance we have. And then also they must have published grievance procedures. But again, what's in those grievance procedures is not outlined very well as either, because that guidance has been removed. Now I'm giving you all this, and it seems like a bleak picture, but when we get into Illinois law, hopefully there will be a little bit more optimism, because Illinois law provides a lot more protection. But what I need to say is that protection really is only for people in higher education. It does not apply to your K through 12 clients, your K through 12 survivors. And so this is information that you need to know for clients of yours who might be K through 12. This is the landscape we're in right now when we're talking about our students who are not in higher education in Illinois. Okay, so the Clery Act has not been changed. The Clery Act was put in place primarily to create transparency through reporting requirements for the school. So basically, a school is required every year to report how many crimes occurred on their campus every year. And this was to ensure that parents and potential students and current students are aware of the risks that are at their school and what they might possibly have to be concerned about. Now, I have a lot of feelings about that. I'm not going to get into them right now, but what we do know is that because schools often only report crimes that happen on campus, that they have determined are actual crimes, that we don't actually get the full reporting. So for anybody who's seen The Hunting Ground, you'll have seen that, for instance, the University of Virginia reported 3 sexual assaults on their campus, or no, less than that, I think just one in 2014 or 2015, but that there had been over 100 reports by students of sexual assault. So that means that they only found that one of those cases was an actual sexual assault, so that's all that they reported. So the Clery Act is there. For whatever worth the reporting requirements are, but they still provide requirements for how a school has to respond. Now, a school is required to have prompt and equitable, not quittable, I forgot an E there, equitable disciplinary proceedings. They have to have published victims' rights and college responsibilities. So that goes a little bit beyond the grievance, just the talking about grievance procedures, talking about what rights does a victim have and what responsibilities does the school have in terms of responding to reports of gender-based violence. And then it also requires certain academic, housing, employment accommodations, even if the student does not wish to formally report. So if a student has been a victim of dating violence, and they go to their school and say, I am a victim of dating violence, I'm not ready to report, but I do need some additional time to complete some assignments while I'm dealing with the trauma of this. The school can't force them to report in order for them to receive that academic accommodation. And I'll go a little bit more into accommodations in a little bit. Okay, so after that bleak picture, we're moving on to what do we have in Illinois. So back in 2016, the Preventing Sexual Violence in Higher Education Act was passed. And what it did was it put into Illinois law a number of the guidance documents that came out through the Obama administration in Title IX. So that's good, because now we have in Illinois law some more requirements for schools that has now been yanked by the current administration. While it doesn't have everything I love, it does have a number of things. Again, I have to emphasize, though, this is only higher education. This does not apply to anyone in K through 12. So what it says is that the schools have to have a comprehensive policy, and there's a long list of what is required in that policy. But the ones I want to emphasize is that they have to have a definition of what consent is. And previously, schools could define consent however they looked at it. They could use the Illinois Criminal Code, which basically says there's consent unless there's force. And but what they did in Illinois is they used the consent definition that is the same under the Civil No Contact Order Act. So I don't know how much Micah got into that during her, she didn't know? Okay. So basically what it says is that consent has to be freely given agreement, that mere submission is not enough, that there doesn't need to be nobody has to fight, yell no, that consent has to be a freely given agreement. So we are not to the yes means yes point yet, as they are in Illinois or in California for their Higher Education Act, but we're better than the Illinois Criminal Code, to be honest. So if you see a school that is using the Illinois Criminal Code consent standard, they are violating Illinois law. I know of one small Christian liberal arts college that is still doing that, and they're fighting me on it. So, well, there might be other ones out there. The other thing is that they did put into place amnesty provisions. Basically, what that means is that if a survivor comes and reports gender-based violence, and that gender-based violence happened within the context of them participating in a rules violation, they cannot be held responsible for that rules violation. So the biggest times you see that is underage drinking and use of illegal drugs. So, I've had a number of clients who may have been smoking marijuana with the perpetrator before he sexually assaulted them, or, they were at a party where there was underage drinking going on. And they can report with the assurance that they will not be held responsible for that rule violation. And that's to make sure that they don't freeze reporting, that people can feel comfortable reporting a crime against them without fear of how that's going to hurt their academic standing. Okay, the Illinois law also provides a variety of reporting options. Almost all the schools that I've seen in the Chicago area have electronic reporting now, and I'll show you an example in a little bit. They can also report confidentially. The schools have to make clear how they can report confidentially. And then they can also do an anonymous reporting. So again, like I was saying, if they don't really necessarily want to participate in the investigation or really trigger something, but maybe just make the school aware that there is an issue, they can report without putting their name on it, so that that information is there in case another allegation is made against the perpetrator. That is there, and it's known to the school. Third parties and bystanders are allowed to report in the place of a survivor. In that situation, especially with third parties, we usually encourage that they get permission from the victim before they report, because schools will immediately jump on trying to investigate and trying to get in contact with the victim. Basically, everyone has to receive annual training. That means anyone who is going to be interacting with students who report gender-based violence, so all of your Title IX people, probably deans, counselors, academic advisors, Anybody who participates on a hearing disciplinary committee. Students, so students don't have to receive annual training instead of receiving it with their handbook during freshman year orientation and then never hearing about it again. And then finally, there has to be a fair and balanced resolution process and appeal. So that means that it can't favor one side over the other. So to get to the enforcement question, this is the biggest issue I have with this law. Great things in this law, but the biggest issue I have is that there's no real enforcement mechanism for the students themselves if the schools are not following it. The schools self-report annually to the Attorney General's office. That starts next month. That will be the first reporting. And basically what it is they say, yes, we are following the law. Here's how many reports of sexual violence or sexual violence, domestic violence, dating violence, stalking we received, and this is how they were yes. I don't know what word you said, but I'm sure they were handled, yes. And so that's basically where we're at, is that schools get to self-report. I come from the realm of, we only have like 10 minutes left, so I need to move on, but again, we're talking about not very strong enforcement language. But what I do love about this law is that it puts in place a system for confidential advisors. Now, what these people are people designated by the school to receive reports from students and to meet with students who have been victimized by gender-based violence, that in a way that doesn't trigger duty for the school to investigate. Now, that's good for the students because there are so many students who just want to know what their options are, to receive accommodations, but without having to go through the whole disciplinary hearing process. And now the schools are required to do that and required to make very clear to the students who those confidential advisors are. The main thing with this is that the confidential advisor is not allowed to disclose any communications unless they've been served a subpoena by a judge. So they can't have the Title IX coordinator come to them and go, come on, just tell me what Susie told you. That would really help my investigation. Or a dean say, if you want to keep your job, you're going to have to tell me who the perpetrator was, or something like that. So they are able to offer the students full confidentiality. Now, I don't know if anybody's here from rape crisis centers that have coordinated with schools to be confidential advisors, but that's allowed under the Act, that advocates from local rape crisis centers or local domestic violence shelters can be assigned as confidential advisors. Just to let you know that if that is the case, or you interact with one of those people for your client, their absolute privilege still applies. So that means they can't even be subpoenaed by a judge, that no one can get that information from them. So the higher the privilege, the higher one applies in those situations. One other thing about confidential advisors is they need to be able to access accommodations. Now, they might have to go to someone else to be able to get those accommodations, and they need to tell the students that they then have to disclose information in order to get those accommodations, but they need to be able to get some form of access to that. So if it's a rape crisis center advocate, they can't say, well, I'm sorry, I can't get you any academic accommodations. I don't know how to get them. The school has to, if they were working with someone externally, they have to tell them how to get that information. Okay. I'm going to skip by this, but I just wanted you all to see kind of what it looks like on a school's website now. A lot of schools used to have, go to the Title IX office or call this phone number. But now schools are required to provide an electronic form of reporting, and a lot of schools do things like this. Just make it very clear. You go to the Title IX page or the sexual misconduct page or whatever, and it's just very clearly like, how do I get help? Where do I get confidential support? How do I file a report? How do I help my friend? If you, I don't know if anybody here goes to hospitals or meets with people in hospitals or right after incidents of gender-based violence, I find that this is, I've heard from advocates who do that this is a really good place to start when they're starting to freak out and they're sitting in the hospital waiting for, the police to come to give a police report or wait for the sexual assault nurse examiner to show up. To say, if they're freaking out about an exam they have tomorrow, to sit them down, pull out your smartphones, have them pull out their laptop and say, let's look to see what options you have from your school, and to search and to look for this page and to look for what options that they have. Again, all of the larger main schools have them very clearly listed on their pages. Okay.
Sorry, and the name of is just Sexual Misconduct and Response and Prevention. That's the website name?
Well, that's the Northwestern one.
Northwestern? Okay.
So if you look for Title IX or sexual misconduct, those are the two big ones that people use. Yeah, or report misconduct or something like that. Okay, so if you have a student who, if you have a client who is a student who has been subjected to sexual violence and they want to report it to their school, either to access accommodations or because they want an investigation done, there are a few things that I suggest you do to help them. The first is you have to choose who to report to. If the person is in higher education, college or above, I highly recommend they go and talk to a confidential advisor first, because then they will receive all the information they can get about their options without triggering a need to report or trigger an investigation. Again, if the student is in K through 12, your main options really are talking to someone called a responsible employee, which is someone who is required to report to the school that something has happened, or to their Title IX coordinator. In a lot of high schools, those are in the student counseling departments. I can tell you it's really hard to find that information in almost all local high schools. But I start with the counseling department or a guidance counselor, academic advisor. I always recommend that you talk to them about their social media privacy settings. What we find is that a lot of our students have their social media wide open, completely public. But by having that completely wide open, they're at risk of continued harassment by the perpetrator or the perpetrator's friends, or if they post something that could be seen as defamation, that getting pulled off of their site and being used against them in a defamation suit. So I always tell my clients, shut down that social media. I don't care if it's Snapchat, Facebook, Twitter, Tumblr, what have you, shut it down. Just make it private. I'm not trying to silence you for right now, but while we're dealing with these issues, while we're trying to decide how to move forward, let's just keep you protected as much as possible. And then finally, what I always tell people is, our clients, is that if there was additional gender-based violence beyond sexual assault, to make sure that they report that as well to the school if they want to report. And the reason for that is the focus right now is so much on campus sexual assault that the schools are forgetting they also have a responsibility to address dating violence and stalking and domestic violence as well. I have a client who was sexually assaulted a number of times by her ex-boyfriend, but there was also domestic violence, physical domestic violence that was viewed by other people that the school ignored. She did mention it to the school, but nobody investigated that. They only focused on the sexual assault, and when they found him not responsible, they basically said they couldn't show that she didn't consent to the sexual intercourse. But they ignored the dating violence that was happening in full view of her parents, in full view of her friends, and in full view of professors. And we are now still dealing with the Office for Civil Rights, trying to decide how they're going to address that. Okay, I'm sorry. I know I'm supposed to be done very soon. A couple, 5 minutes? Okay, thank you. So I've been talking a lot about accommodations, and that is a place that you can really help students if you're an advocate, is to help them think through what types of accommodations are they going to need while they are going through a process after they report, or even if they don't want to go through the process of reporting an investigation. Do they live in the same dorm as the perpetrator? Do they want to move out of that dorm and be someplace safer? Do they work in a forward-facing, outward-facing job, like giving student tours, that they would be worried about running into the perpetrator? Do they, are they having a lot of trouble keeping up with their deadlines for their exams, for their papers? And to think about what types of accommodations they're going to need, and to help them craft and request those from the school. What I do want to say is that previously it used to say that the survivor could not, under Title IX guidance, that the survivor could not be made to bear the brunt of these accommodations, such as if they're both living in the same dorm, they couldn't force the survivor to move. Under the new Title IX guidance, that's been removed. And it's basically said they cannot favor the survivor over the respondent, or they say complainant over the respondent, because the current administration doesn't believe anybody's survivors, I guess. So that's the position we're in. It used to be that they'd say mutual no contact orders or directives from the school were disfavored. Now it's required to do mutual no contact directives. So we're, again, in a position where everybody wants it to be completely equal and fair, but what it will really mean, and I believe, is that the survivors will bear the brunt of any of these. So that might be something your clients need to take into account as well. Okay, so if they do an investigation, they actually get to the disciplinary procedures. The question is, what is required? Because of our very limited time, the main things I want to point out that are changes is that Title IX no longer, well, neither does Illinois law, require a hearing for disciplinary proceedings. And that, in fact, informal resolution may be allowed if both parties agree to it. What this means is mediation. That used to be explicitly prohibited under Title IX. Now it is allowed. They do say if both parties agree to it, but as we all understand about power dynamics, who knows if that's really freely given agreement. And then finally, the standard of proof. Illinois law says preponderance of the evidence. That means more likely than not, 50% and a feather, however you want to put it. So the lowest burden of proof, the same for civil no contact orders, for orders of protection, for a lot of our civil laws. But under Title IX, schools are now allowed to use the clear and convincing evidence standard, which is a much higher standard. It's like, I don't know, 70%, I guess, true. So that might apply to your K through 12 students. Schools can decide if they want to use that, but at this point, I haven't heard of any schools changing it, but they now have a right to do that. Okay. For the actual disciplinary procedures themselves, the biggest changes are that under Title IX now, it's not clear if both parties get to cross-examine or just the respondent gets to cross-examine the survivor. But basically that's what they're now allowing, is that the parties can be cross-examined by the other parties, whereas that used to not be allowed, and it's still not allowed under Illinois law. So college and above in Illinois, you can't do any cross-examination. K through 12, you might be able to. And then finally, the appeal I want to point out. So what it's changed under Title IX is that the right to appeal is only allowed under Title IX to the respondent, so to the perpetrator. Schools can decide to allow both parties to appeal, that to be able to appeal. But now under federal law, it's only a right for appeal for the respondent. In Illinois, college and above, both parties have the right to appeal equally. Okay. I talked about this a lot, so I'm going to skip that. What this changing landscape says to me for Title IX is that we're going to be having for our clients who are K through 12 to start looking at external legal proceedings, to work with them to maybe get CNCO's orders of protection in order to ensure that schools have to abide by those, to have to put some accommodations and some things in place that are mandated by the court as opposed to waiting for the school to do the right thing. And so that's kind of where we are right now. Schools cannot ignore a CNCO, but they do have options for how they follow that. We're going to try to get the judge to provide a little bit stricter guidelines, but we'll see what comes up with that. Okay. So again, the school violations, it used to be that we go to the Office for Civil Rights, we file a complaint, and then it'd take 3, 4, 5 years for them to decide whether or not a school violated, and maybe put in a resolution agreement where the school agrees to make changes. We have decided not to really take that step anymore because we don't see that doing very much. But what we are trying to do, thank you, is look at how we can encourage actors in Illinois to change the laws here in Illinois to provide enforcement. So if you all are probably at organizations that we might be contacting to help us help support a legislative effort, but just to let you know that is something CASE is looking at to make the Illinois law enforceable and make it apply to K through 12 to help protect students. Okay, and I'm wrapping up. Again, I do want to say defamation risks. Social media lockdown is the most important thing. That will help, but again, there is a lot of money being put towards men's rights groups to help respondents sue schools and sue survivors for what they see as defamation. It is a huge risk. If you do have a client who is facing that risk, I'd be happy to talk to them. We have some options. We have some pro bono attorneys who have agreed to take some of those cases. So just to let you know that.